Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Welcome to Triage. Today we're talking about a topic that comes up in almost every internal investigation in the healthcare context, specifically how to protect attorney-client privilege, and when you're dealing with issues particular to fraud and abuse. Today I'm joined by my colleague from K&L Gates Chicago office, Nora Becerra. Nora is a healthcare partner in our Chicago office in the practice group and routinely handles investigations involving internal audits, government subpoenas, and civil investigative demands. Nora, thank you for being here.
Thanks for having me, Limo. As you know, this is one of those concepts that sounds straightforward, but can quickly get complicated in practice. So I'm really excited to discuss some practical guidance for in-house counsel and compliance teams navigating these privilege issues in real time.
Well, let's just jump right in. So, as attorneys who are listening would know, many people know what privilege is, and others have, certainly heard the word. But let's talk about how the idea of attorney-client privilege actually shows up in your practice.
Sure. Yeah. Well, at its core, the attorney-client privilege protects confidential communications between privileged parties. So in other words, a client and their attorney acting within their legal capacity for the purpose of obtaining legal advice. So it's a protection that can shield communications from disclosure to third parties, and therefore it can be one of the most valuable tools, whether you're dealing with a government subpoena, whistleblower complaint, or an internal compliance review. But it's also one of the easiest to lose if you're not careful.
Well, let's talk about this really in the context of fraud and abuse in the healthcare space.
In fraud and abuse investigations, such as False Claims Act exposure, anti-kickback statute issues, Stark law concerns, organizations are often dealing with regulators in the background while simultaneously conducting routine internal investigations and audits as part of their everyday compliance functions. So unless an investigation is initiated by a government subpoena or CID that's directed to the Office of General Counsel, the compliance department is usually the first to know about a potential fraud and abuse issue. And it's up to them to determine when to escalate a hotline complaint, billing concern, or potential kickback, or whether to involve legal at all.
Well, in that context, when compliance is the first responder, when does the question of privilege actually come up?
Well, the short answer is that it often doesn't. Compliance communications are not privileged unless they've met the necessary elements. So again, communication with an attorney that's made for the primary purpose of seeking legal advice. So in these situations, the key question for compliance is, when does this become a legal issue requiring counsel's involvement? And how do I make it clear that counsel is now providing legal advice and directing next steps? So if you wait too long to involve legal, you risk creating a body of documents that aren't privileged, things like internal emails, preliminary findings, or interview notes that then become discoverable.
So if the compliance department is doing its job and documenting, that can actually become evidence that's used against the organization.
Exactly. And in a False Claims Act investigation or government audit, those materials can become central evidence and open you up to significant liability.
Well, one of the things that often we get asked is the overlap between compliance and legal and the tension between who is responsible for what and what those roles are. How should organizations be thinking about where those lines fall?
That's absolutely right. Compliance and legal roles often overlap, but they're not the same. Communications are only privileged when their primary purpose is legal advice. Therefore, organizations need to clearly define when an issue is being escalated to legal.
What does that actually look like in practice?
It can be as simple as documenting that in-house counsel or outside counsel is directing the investigation. And once that happens, communications and work product need to flow through counsel.
And we've always heard about the idea of copying in counsel. Does that actually shift in terms of what the roles are?
Great point. And no, simply CCing a lawyer isn't enough. Courts typically look at the substance, who is directing the work and why the communication even exists. And in some cases, copying lawyers unnecessarily or overusing attorney-client privilege labels can actually dilute the argument that a communication was truly for legal advice.
That's interesting. So if you do it too much, then the court might actually a court might consider that to be incorrect or something that's not actually properly being used.
Correct, correct. And it weighs against privilege.
Okay. Well, let's talk about some common mistakes. What do you see? What are the things that happen regularly that you think are probably bad practices?
One big one is oversharing. Typically compliance teams tend to be collaborative by nature, but broad internal distribution can waive privilege.
So, like in terms of the number of people who are getting copied on things, the lists of people.
Correct, especially if this information is not necessary for them, and in terms of the legal advice that you're providing, it's not relevant for legal action.
So, what about sending updates to like leadership and finance and operations?
Again, same rules apply. So if those individuals don't need the legal advice to perform their roles, including them can actually weaken a privilege claim.
Okay, so what about business discussions versus legal?
That's another common issue. Mixing business and legal discussions can get you into trouble very quickly. For example, an email chain that starts with legal advice, but then turns into operational decision making, or forwarding a legal memo that goes beyond those who need it for legal purposes, like repurposing it for general business or broad board updates, is a no go.
I'm assuming that probably does happen all the time and can create a risk. Let's talk about this from a practical perspective. If you're a compliance officer or in-house counsel listening to this, what should that person be doing differently tomorrow?
Well, first, you want to have a clear escalation protocol. You want to define the triggers for when legal must be involved, such as potential fraud, overpayments, or government inquiries. Second, you want to make sure that once legal is involved, you centralize those communications. Use counsel as the hub rather than having parallel discussions happening across departments.
I can see that that would solve problems to actually have that sort of centralized control.
It really would. It really would. Third, I would say, just be disciplined about documentation. Avoid speculative language in emails, phrases like this looks illegal or, we've been doing this wrong for years.
Well, that would be the kind of thing that would certainly want to be avoided. I mean, also, again, I mean, it may be at some point that there might be an intentional decision to waive privilege, and those types of statements could be problematic.
Absolutely. Absolutely. So you want to avoid those at all costs. If you really feel the need to discuss those things, pick up the phone. Do not, send that email.
All right. Well, let's talk a little bit about interviews. Often there's interviews that are started in the compliance function. What should teams be thinking about with respect to those types of interviews?
Sure. Well, the key here is to be intentional about when interviews shift from routine fact finding to part of a legal investigation. So once there's potential legal exposure, counsel should be involved, and ideally, they should be the ones directing the interviews. In some situations, bringing in outside counsel can help reinforce that the work is for the purpose of legal advice, especially since in-house counsel often wear both legal and business hats. So again, with an eye on maintaining that privilege, it's sometimes really helpful to get outside counsel involved.
So really, it sounds like it's about being clear about those purposes and roles.
Exactly, exactly. And once counsel is directing the process, interviews should include what's commonly called an upjohn warning. So making it clear that counsel represents the organization, not the individual, that the interview is being done at the direction of counsel and therefore is privileged, and that the privilege belongs to the company. It's also good practice to confirm the employee understands and agrees to proceed.
I know I've heard people talk about how awkward it is to do that. So, but what happens if it's skipped? If you skip the upjohn warning?
Well, it is awkward, but it's important. And while it doesn't automatically waive privilege, it can create real problems down the line. For example, an employee may believe the lawyer represents them personally, not the company, which can lead to disputes later on, especially if the company decides to waive privilege and disclose information that the employee objects to. Not only can this complicate privilege claims, but in some cases, it could even lead to challenges to counsel's role and lead to motions to disqualify counsel or limit the use of the interview information.
That all makes sense. It seems like that clear communication and warning does help ensure what what happens. Let's talk about some other practical missteps. What else have you seen in the context of interviews that you've seen that have been could have been avoided?
A few come up pretty often. One is how interview notes are handled. So, informal notes that are widely shared can create risk, whereas interview memorandum prepared by counsel's direction and kept within a limited group are much easier to defend as privilege. You also want to avoid recording interviews or creating verbatim transcripts unless there's a specific reason to do so, because those can also become discoverable and are harder to characterize as attorney work product.
Yeah, that's a good pick. I can certainly see that people, that tendency toward documentation can actually sometimes undermine the privilege.
Absolutely. And it's also important to be careful about any follow-up emails summarizing interviews. So if those summaries again are circulated broadly or mix factual recaps with business commentary, you can really undercut privilege. Interviews are often where the most sensitive facts come out, so they're also where privilege needs the most protection.
Got it. So now let's talk about when the stakes are different and higher. What happens when an entity gets a subpoena or a civil investigative demand and the government starts asking questions? Does that change the privilege concern?
So this is where organizations tend to feel pressure to cooperate and sometimes over disclose. Providing privileged materials to the government can waive privilege more broadly. So you never want to do that, especially depending on the jurisdiction. But often it's better to just share the facts rather than the underlying documents themselves. For example, providing oral briefings or written summaries that don't actually reveal the privileged communications.
That's still cooperating, though.
Exactly, exactly. It's about balancing transparency and keeping that protection while still cooperating.
Well, this has been really helpful. If you had to tell compliance officers and in-house counsel dealing with compliance types investigations with one major takeaway from our conversation, what would that be?
I think the underlying point here is to be intentional. Privilege doesn't just happen. You have to really design your investigation process to protect it from the start. Once documents are created and distributed, your options narrow very quickly.
Well, that's a good note for us to end on today. Nora, thank you for joining us, and thanks to everybody listening. If this episode was helpful, please consider sharing it with your compliance team.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.